All right, future legal eagles, listen up. Sooner or later, every single one of you is going to get a call about one of two things. What happens when someone can't take care of themselves anymore, or what to do after they've passed away. Today, we're pulling back the curtain on guardianship and estate settlement. And trust me, this isn't just about passing an exam. This is about learning how to protect people when they need it most. Okay, so here's our game plan for today. We're going to start by figuring out what kind of legal ballpark we're even playing in. Then we'll get into the nitty-gritty of guardianship, that's for the living, and then estate settlement for the deceased. We'll look at the different roads these cases can take, and we'll finish up with the really crucial stuff, the legal safety nets for everyone involved. First things first, let's get our bearings. It is absolutely critical to understand that we are not in the world of a normal lawsuit here. We're talking about something called special proceedings, and believe me, that one distinction changes the entire game. Now, take a look at this. This table really lays it all out. Think of an ordinary civil action as a classic fight. A plaintiff versus the defendant started with a formal complaint. It's adversarial from the get-go. But a special proceeding, that's a different animal. Its whole purpose is just to establish a fact or a status, like this person is legally deceased. You start it with a petition, and there isn't necessarily an opposing party. And get this, the appeal period is double, 30 days, not 15. That's a huge deal. So, let's dive into our first big topic and see how this all works in the real world with guardianship. This is where the law steps in to protect people who, for whatever reason, just can't protect themselves. You're going to hear this term a lot. Parens patriae. Sounds fancy, right? All it means is father of the nation. And honestly, this one Latin phrase is the bedrock of the entire concept of guardianship. It's the idea that the state has a duty to step in, not as an enemy, but as a protector. Which, of course, leads to the big question. Who are we talking about here? The word incompetent isn't something you just throw around in court. It has a very specific legal meaning. So, let's break down exactly who falls into this category. So this is what the law is looking at. It's a very specific list. You've got people under civil interdiction, which basically means their right to manage their own property has been taken away as a penalty. You've got prodigals. Think of someone who's just blowing through their inheritance, totally wasting it. And of course, people of unsound mind. But crucially, it also covers people who, maybe because of old age or a disability, simply can't handle their own affairs and are at risk of being taken advantage of. So how does this actually happen? Well, it's a careful process. It all kicks off when someone files a petition. The court then schedules a hearing and makes sure everyone is properly notified. That's especially important if the potential ward is over 14. The court vets the candidates, looking for the best fit, and then finally appoints someone and makes them post a bond. All right, lean in for this one, because this is a piece of advice I give every junior lawyer. That bond, it is not just a formality. Think of it as the ultimate insurance policy. It's the financial guarantee that the guardian is going to do their job honestly and that the ward's property is safe. It's what gives the whole process teeth. Okay, let's switch gears. We've been talking about protecting the living. Now let's talk about what happens after someone has passed away. We're moving into the world of estate settlements. When you get one of these cases, the first question you always ask is, did they leave a will? Because the answer to that one question sends you down two completely different roads. If there's a will, that's testate succession, and you'll have an executor. If there's no will, it's intestate, and the court has to appoint an administrator. Now, you might be thinking, all this sounds complicated and involves a ton of court time. And it can. But luckily, the law has some shortcuts, some express lanes, if you will, for when this situation is straightforward. Okay, this is a classic bar exam topic, so pay attention. You've got two main shortcuts. First is extrajudicial settlement. The big thing here? No court at all. But the catch is you need three things. No will, no debts, and every single heir has to agree. On the flip side, you have summary settlement. This is a simplified court process, but it's only for estates of small value. The cool thing is you can use it even if there are debts, and you don't need everyone to agree to get the ball rolling. So, we just said summary settlement is for an estate of small value. What exactly does that mean? Well, the law gives us a very specific number to remember, and that number is 10,000 pesos. Lock that figure in your mind. If the gross estate is 10,000 or less, you can use this much simpler court process. All right, now for the nitty-gritty of procedure. This is where things can get tricky, kind of like navigating a maze. And you have to be careful because one wrong turn, like filing in the wrong court, and boom, your entire case can get thrown out. You're right back at the start. Here is another number you absolutely have to know: 2 million pesos. This is your new jurisdictional guidepost for estates. It's the dividing line. If the gross value of the estate is over 2 million, you're going to the regional trial court, the RTC. If it's 2 million or less, you file with the municipal trial court, or MTC. Simple as that. Now, it's so important to understand what the probate court actually does and what it doesn't do. Think of the court like a bouncer at a club. Its job isn't to judge what's happening inside the party, who gets what. Its only job is to check the idea at the door. Is this will legit? Is it authentic? They're only looking at the extrinsic stuff. Was the person of sound mind? Were the signatures correct? Was there any fraud? They generally don't get into whether the will is fair. So the estate is settled, the heirs get their inheritance, case closed, right? Well, not so fast. The moment that happens, the law starts a 2-year countdown clock. For 2 whole years, the door is still open for creditors or for heirs who are left out to come forward and make a claim. It's the law's way of balancing getting things done with making sure things are done right. And that brings us to our final section. And honestly, this might be the most important lesson for you as a future lawyer. What happens when the system fails? What happens when someone gets wrongfully excluded or cheated? I want you to burn this Supreme Court ruling into your memory. It is a game changer. The court basically said, nice try, but you can't use an extrajudicial settlement as a tool for fraud. If an heir was left out, if they had no notice, then as to them, the settlement is a total nullity. It's like it never even happened. And that means those time limits we talked about, like the 2-year rule, they might not even apply because you can't put a time limit on something that was void from day one. So here's the bottom line. The thing you write down in big, bold letters. Years from now, when a client walks into your office and tells you they were cheated out of their inheritance a long time ago, don't just look at the calendar. Remember this: a fraudulent deal doesn't magically become legit just because time has passed. The law provides powerful ways to make things right. So we've come full circle, right? Right back to that idea of parens patriae, the state stepping in as a protector. But I'll leave you with this question to chew on as you move forward. When the state acts to protect its citizens, where is that line? When does noble protection tip over into overreaching control? That's a question you'll be dealing with your entire career. Thanks for joining me for this explainer.